Hi everyone, I'm Sabrina.
And I'm Jonathan, and we are the lawyers at VarityLaw.
Since we started our monthly videos, we have gotten a lot of great client response. So now, due to popular demand, every 6 months we will answer all of your most pressing questions.
So let's start. Please note that all client names will be changed to protect their privacy. Now, Sabrina, this question is from Michelle and her family. Michelle and her husband want to buy real estate property, but they don't have enough funds. So Michelle's mom is offering to pay for the down payment and help with the mortgage payments. However, due to tax reasons, Michelle's mom is not going to be on the deed. In this case, does her mom have any legal right to ownership of the property?
Strictly speaking, no. Only the owners and lenders who are registered on the property have a legal right to the property. So let's imagine Michelle and her husband are selling the property. A real estate lawyer will do title search and see only Michelle and her husband on the deed. The only other thing registered is the first mortgage they took out from RBC. Nowhere is the mom's name found. So when selling the property, the money will only go to Michelle, her husband, and RBC. No money will go to the mom.
So Michelle's mom won't get anything even though she paid for the down payment?
Most likely, yes. Unfortunately, mom doesn't have much legal entitlement unless she protected herself beforehand. Her name is nowhere on the deed of the property, and she doesn't have legal ownership or any say over the property. To protect herself, she should have gotten a lawyer to register a second mortgage in her name before she gave the down payment. If she did this, then when Michelle sells the house, the money will first go to RBC, then to the mom for paying off the down payment, and finally the leftover to Michelle and her husband.
But how come a receipt showing the mom gave them the down payment isn't enough?
It's not enough for two reasons. First, there is no document showing the purpose of the money. Michelle could argue the money is a gift, not a loan. There is no document to say otherwise. Second, the mom's receipt is not registered on the property, so no real estate lawyer would know of its existence. When doing the sale, no one would know that there is this receipt, and the sale money would just go to Michelle, her husband, and RBC.
That's scary. Definitely necessary to have legal protection before lending out the money, even if it's to family members.
For sure. Okay, John, our next question. Frank says that he bought a property and paid for it in full. He is the only person on the deed. A few years later, he got married and his spouse moves in. Does this mean his spouse is entitled to the property even though she's not on the deed?
Yes, that is correct. Frank's spouse will be entitled to the property because now the property is a matrimonial home. The definition of a matrimonial home is basically any property that is ordinarily occupied by the property owner and their spouse. It doesn't matter that the spouse's name is not on the deed, and it doesn't matter that the property was purchased by Frank before they got married.
So the spouse can possess the property even if they're not on the deed. Frank also says he intends to buy an investment property under just his own name in a few years. So will both properties be considered matrimonial homes?
It depends if Frank is living in both properties with his spouse. The key is really whether they are ordinarily living in there. But to be certain, what Frank can do is come to a law office with his spouse and designate his property A as the matrimonial home. Once they pick one property to be the matrimonial home, all other properties will not be considered the matrimonial home as per the Family Law Act. This is a very underused method that would easily resolve a lot of disputes during marriage breakdown.
Oh, wow. But would this apply if the investment property is a cottage? Many people ask that if both the house and the cottage would be considered as matrimonial homes.
Yes, this does apply to cottages as well. If Frank registers the designation on property A, then cottage B would not be considered a matrimonial home and ownership would just follow the deed. So if cottage B is just under Frank's name, then it belongs to Frank and is not a matrimonial home.
Wow, that is definitely an essential but unknown rule to most people. Glad we could answer that one as well.
Next question. Lisa asks, I invested a sum of money into a corporation with promises of investment returns. It's been a few years and I didn't receive any returns. Now I want to exit the corporation and get my investment back, but they're refusing to let me do so. What should I do?
Well, Lisa, like we mentioned above, it's not enough that you simply have the receipt showing you're invested. There must be legal documents showing what is the purpose and terms of your investment. Again, worst case scenario, the corporation could argue that you gifted that money to the corporation.
That is horrible.
Yeah. Well, even if the corporation acknowledged that the money was for an investment, there could be two possibilities. Lisa's investment could be an at-risk investment, meaning she used the money to buy shares and become a shareholder. But if the corporation loses this investment, loses their money because they're not managing it well, then her investment will still be lost. At best, she can try to sue the directors if they made obvious mistakes like getting a mortgage with very high interest rate, but this is hard to prove because the corporation does protect its directors from most personal responsibilities. Alternatively, the corporation could say, you did invest with us and it's a loan. This is the safer option as the corporation is obligated to pay back any loan. But again, if the corporation runs out of money or goes bankrupt, there's little Lisa can do.
So what should she have done?
She should have done a proper procedure at a business law firm. If she wants to become a shareholder and receive dividends, then she should have done a share purchase transaction. During this process, we will check to see if the corporation has any debt, lawsuits, or other problems. She could get her accountant to review the corporation's financial statements. All of those will prevent her losing money.
What rights would she have as a shareholder?
Well, first, she must ensure she is indeed a shareholder. The corporation's share certificates must list her name and be signed by all the directors. Then, she should do a shareholder agreement, which will say when and how she will get dividends, which are the return on her investments, and what to do if she wants to leave the corporation and get her investment back.
What are some common options for getting her investment back?
So, option one could be the corporation buys back her shares at fair market value, or the existing shareholders buy them back.
But how would they determine the fair market value? What if Lisa thinks it's $500 per share and the corporation thinks it's only, say, $200 per share?
Well, that is hard to say. The best way is for all the shareholders to have a meeting and decide on how much shares are worth every year. Just like real estate, they can just decide this amongst themselves as long as it's in agreement between the buyers and sellers. But if, like most people, Lisa didn't do this and wait many years later to determine how much price is per share, then at this point, it's hard for them to agree, and they will likely have a different opinion on how much each share is worth. In that case, they must hire a professional appraiser to decide, and the appraiser is very expensive.
Now, what if it was a loan?
Well, if it's a loan, we will still do the same searches to make sure the corporation isn't going bankrupt or owe any money. But we will do loan documents instead of shareholder documents. If Lisa wants to be really secure, she can also request a collateral. If the corporation owns an office that is worth a decent amount of money, we can register Lisa's loan onto the property. That way, even if the corporation is going bankrupt, Lisa can quickly sell the office and get her investment back.
Unfortunately, though, it doesn't seem like Lisa has any of those documents.
Yeah, it seems like that's the case. Now, she can only try to negotiate and redo those documents, or if she cannot, they must go down the costly litigation route. As there is no documents to show the intention of the parties at the time, the result of litigation will be uncertain.
So the safest way is to have the proper legal documents and procedures ready and then give the investment.
Absolutely.
All right, well, it seems that is all we have time for today.
Did we answer all your questions? If not, please post your questions in the comments below, and we will catch you in our next video. Thank you for watching, everyone.